En cuanto el profesor Neil Cohen aparezca, le presentaré. Y aquí lo
Here he is.
welcome. I'm very happy to see you again. Very happy. I think the introduction that I can do to Neil ought to be very personal. When we began to plan this, I have had a conference call, a Zoom with Neil, and I asked Neil, how we can do this? Who people do you think that should come? And if we are here, and I should say also that in part the structure was something that Neil helped us to make that. Unfortunately, at the end of the day, the doctor said, Neil, you shouldn't cross the Atlantic with this pain. And and he paid attention to the doctor's instruction. Anyhow, today, he has been joined to us from the very beginning. He has been hearing Steve and Stephen and Ed, and also Ignacio. And so we thought that this was the best time for him to appear on the timetable. I mean, now it's a good time to talk in Brooklyn, in New York, where Neil is. Well, thank you very much, Neil, again, and the floor is yours.
Well, thank you, everybody. And hello and greetings from Brooklyn, New York. I do apologize for my inability to attend this conference in person. I was greatly looking forward to it, and I'm sorry not to be there with you. I'd like to thank all of the organizers of this conference. It's been a wonderful conference, and I've learned so much from listening to the various speakers. And thanks particularly to Professor Moran for inviting me. I've known him for almost 30 years now, so he was very talented and fear of the Unidroit that prepared the United Nations on the assignment of receiving international trade, and he did a remarkable job on that, and I've been privileged to know him for quite a long time now. If you just give me a moment, I will share my screen so I can so you can see the PowerPoint slides that will accompany this. It's just a moment away. I'm sorry. Here we are. And we'll be all set. There we are. Okay. So the focus of this conference has primarily been on the emerging law of electronic records as an item of commerce. We've talked about digital assets. We talked about controllable electronic records as the U.S. Uniform Commercial Code refers to them. And quite obviously, this is an important area for law reform and for legal development and for international cooperation. And again, we've heard so much today about what's going on in that field. While that law has been developing and while those efforts have been going on, there has been simultaneously another initiative to try to reach consensus on legal rules to govern commerce that's made possible by the emerging digital economy, and that is commerce in data. And I've been asked by the organizers as part of my contribution to this symposium to provide a brief introduction to that initiative. And so that's what I'll be spending the next 15 minutes or so doing. And again, I'm referring to an instrument that was just published in the last year called the ALI-ELI Principles for a Data Economy, Data Transactions, and Data Rights. I was privileged to be the co-reporter for that effort, along with Professor Christian Venderhorst of the University of Vienna. And you should be aware that Steve Wise, whom you heard speaking just a while ago, was one of the chairs, one of the co-chairs of that effort. Why does this instrument exist? Why do the American Law Institute and the European Law Institute seek to identify principles for a data economy, particularly those that govern data transactions? And you can see three reasons there on the screen. This is an emerging aspect of the economy that has great commercial importance, enormous commercial importance. Data transactions represent a very large and growing part of the economy now. Because of the nature of data and the nature of the ability to transmit data, there are very low borders to cross-border transactions, and so international cooperation and harmonization is particularly important in this area. And finally, because of some of the things that are unique about data transactions, current legal concepts simply are insufficient very often to govern modern transactions, or their application isn't obvious. In other words, current law is problematic, can result in inappropriate rules or legal uncertainty. In both cases, that can deter transactions or add to the cost of data transactions. And as a result, the American Law Institute and the European Law Institute decided that this is an area that could benefit from law reform and harmonization. Now, people at this conference probably know a lot about one or the other, if not both, of the two sponsoring organizations of this international initiative. The American Law Institute has now been around for 101 years. It was founded in 1923, as Steve noted earlier, by some very prominent people in American law, including a Chief Justice of our Supreme Court, a former president, other judges, and academics. Its purpose, as you can see, is to promote the clarification and simplification of the law and adapt it to social needs. The European Law Institute, much newer, founded in 2011, in many ways was inspired by the American Law Institute, and you can see its purpose stated there as well, to conduct and facilitate research, make recommendations to the practical guidance of European legal development. Both of the organizations, unlike the organizations we've heard about earlier, unlike Unidroit, the Hague Conference, the United Nations, both of these organizations, the American Law Institute and the European Law Institute, have no official status as law-creating organs. They are organizations of people. Their power comes not from formal power granted to them by states, rather their power comes solely from their persuasiveness, not from any aspects of sovereignty. The American Law Institute historically focused on law of the United States, but it has been broadening that focus. The European Law Institute is focused, as its name suggests, on European law. This is the first joint project of the two organizations, a hands across the Atlantic Ocean arrangement to try to bring about some helpful and useful law reform on a transnational basis. What are the purposes of this project, the principles for a data economy? There are four there you can see listed on this slide. The first two are in the nature of law reform. The second two are in the nature of guidance to parties. we hope with these principles to move towards coherence and harmonization of law and legal concepts that govern the data economy, and not only that, but to encourage further development by courts and legislators worldwide. But not only is the goal to influence law reform, but also to provide assistance and guidance to parties engaging in data transactions, to inform the development of best practices and emerging standards, facilitate things like model agreements and provisions to be used on a voluntary basis by parties in the data economy. So there are, again, two agendas here. One is law reform, and the other is assistance to the parties that enter into these transactions. What do the principles for a data economy address? The primary focus, again, is on transactions in large quantities of information that themselves are an asset, a resource, or a tradable commodity. This isn't the only possible definition of the term data, so we needed to we needed to put borders on what we were addressing in this project. And so two things we chose not to address are what are sometimes known as functional data, data that delivers particular functions like computer programs. We're not addressing computer programs in this project. And similarly, we're not addressing data that represents something else, the main purpose of which is to represent other assets. So for example, while crypto assets could be considered to be data, that sort of thing is not addressed by this project. Rather, it's addressed by the projects about which you've heard so much over the last day and a half. Similarly, this project defers to some other important areas of the law. It does not address issues of data protection and data privacy where those rules exist. You're all familiar with those rules and their great reach. Rather, the ALI-ELI principles defer to data privacy and data protection law. They assume that the parties will comply with the requirements of that body of law, and they govern the commerce of it, subject, of course, to data protection, data privacy. Similarly, the principles defer to intellectual property law. But within its area of primary scope, there are three issues, three types of rules that the ELI principles address: data contracts, data rights, and some third-party aspects of those rights. What I'd like to do in the time available, and I do realize I'm the only thing standing between you and adjournment of the conference, what I'd like to do is focus on what the ALI-ELI principles do with respect to data contracts. The principles define a data contract, as, not surprisingly, as a contract the subject of which is data, and provides a definition of data, primarily focusing us not on any piece of information that may exist in any form, but primarily the types of data that are typically stored in machine-readable format for automated processing. You might have heard the phrase big data. Well, the types of transactions that big data enters into are really the primary focus of these principles. The principles, the data economy principles provide 11 principles to govern data contracts, and you can see those in detail in the published version of the ALI principles. Two of the principles are of general applicability to all data contracts, while 9 of the principles are targeted to particular types of data contracts. And here are the 9 types of data contracts that the ALI-ELI principles have identified. They all are contracts about data. They all are related to each other. They all share some issues in common, but they have different commercial functions. They have different needs, and as a result, they are addressed sometimes together and sometimes separately. If you look at these, you'll see that the first 5 contracts for the transfer of data, contracts for what we call simple access to data, contracts for exploitation of a data source, those for authorization of access, and those for data pooling are about ways of giving parties access to data. While the last 4 contracts for processing, data trust, data escrows, and data marketplace contracts are more in the nature of service contracts with respect to data. Again, these contracts have different types of attributes, and as a result, what the ALI-ELI principles do is to provide related but slightly different rules for each of these types of contracts. The ALI-ELI principles start off, however, by recognizing that data contracts are contracts, and they'll remain to be governed by the wide variety of contract doctrines that apply in every legal system, subject to the law reforms that are specific to this area. And as a result, the first thing that the principles do is to identify a hierarchy of legal rules to govern data contracts. The first set of rules are a legal system's mandatory rules, rules of law that can't be derogated from by agreement. The second bullet point, probably the most important one, is that data contracts should be governed by the agreement of the parties. Contracts are the product of agreement, and parties know what is best for their deal. And so as long as they don't vary from rules that cannot be derogated from by agreement, the general idea is the agreement of the parties should be paramount. But no agreement is complete. Many people have said contract law is the law of incomplete agreements. And so what we need is what to do when parties have not agreed about something, have not anticipated an issue, have not had the time to bargain about it. And you can see the next 4 bullet points are a hierarchy of sources of rules to fill in where the parties have not themselves governed a particular area. And you can see them in a hierarchy. Rules of law developed specifically for data contracts, application of default by analogy, and finally at the bottom, general principles of law. And the theory is that that hierarchy can identify what the source is of rules governing data contracts. The second general point that the principles make is that legal principles and the contracts of the parties should be interpreted in their context. And in the context of data contracts, it's very important for legal rules to recognize some things that are unique or special about the data context. One is that first bullet point there, that the fact that data is a combination of both physical manifestations and the information that they record. Second point, a very important one, is while data is an important resource, there can be many copies of data at the same time, and it can be used at the same time by many different people. Unlike an object, unlike a pen or a book or an automobile, that if one person has possession of it, somebody else does not. Many people can have access to it at the same time. Property theorists say that data is a non-rivalrous resource. Finally, data tends to grow on itself. It's often derived from other data, and you can have original data and derived data coexisting. And finally, physical location of the storage of data can change quickly, can change easily. It's often accessed remotely, and as a result, where the physical manifestation of the data is, where the server is, or the like, is typically of very little importance. And since the location can change so quickly and so easily and so costlessly, it's particularly important to have principles that cross borders well. The legal rules governing data should not depend, for example, on the location of a particular server or server farm. The principles then go on, as mentioned earlier, they address these 9 types of data contracts. And within each type of data contract, the principles do 3 things. One is that they provide a more detailed definition of the transaction type. And then they recommend default rules, rules that will apply in the absence of agreement by the parties with respect to the data contract, focusing on 3 issues. One is the manner in which the data supplier is to perform its obligations. The second is the characteristics or qualities of the data. In U.S. legal parlance, we might refer to that as express and implied warranties. What characteristics does the data have? The data must have the characteristics agreed to by the parties, but there are also some general duties of the data provider about the quality and nature of the data that will be there unless the parties agree to disclaim them. And finally, there need to be contract terms about the rightfulness of the recipient's use and control of the data. This is obviously just a very brief survey of what the data economy principles do. Again, they were developed really concurrently with the digital asset principles that we heard about earlier, and with the U.S. Amendments to its Uniform Commercial Code. They are very soft law. They're designed to guide the reform of the law. They are not yet law themselves, but this is an important part of the digital economy that operates very often in parallel with the law of digital assets. And it's important to be aware of this as a subject of future law reform. We suspect that many of the people who've been involved in the reform with respect to digital assets will also be further involved as the ALI-ELI principles begin to become influential in law reform. And again, we can hope in the future perhaps to have some international legal instruments in this area. Well, this is only a survey of what the ALI-ELI principles do. I do appreciate the opportunity to describe them to you in brief, and I look forward to learning how they are influential in the future, and their influence will be determined in large part by many of the people in the room now. I'm available for any questions about these either now or at any point in the future. I'm easy to reach. And I look forward to learning more from all of you and your reactions. Thank you very much.
Thank you. Thank you. Thank you, Neil. Thank you, dear Neil. Thank you very much. It is very important to realize that I did forget that the reason why I asked Neil is because he was at the head of the working group drafted the American Law Institute data principles, data economy principles. So thanks again. But at the same time, we have to reckon that the time is absolutely limited, and that we can't do everything that we would like. So I expect that Neil could join this in a paper and put that to our future book. And anyhow, if someone has any question, please, on the issue, you can write me, and then I will resend to Neil the question of the query to Neil, because something that is very important also to underline, the generosity that Neil and the colleagues exhibit. You know, it is so clear that I thanks to them. And but we have to finish because Carmen told me that we are waiting someone from the Diputación. If he's not coming in just a second, she will close the session and we will eat something and go to Madrid because Madrid waits for us, so to say, no?